Thank you, Senator, for kind of going over some of the changes. And regrettably, I haven't had time. We've been so busy with our last-minute work here to fully digest all the changes and get copies of the entire House bill as passed to look at all those amendments. But I guess my biggest concern had been one that you and I had talked about in the past. And in fact, at your suggestion of just filing a standalone bill, I did. I was concerned about what we consider the community safe zones, the areas that are really important for people to worship, like churches, to go to school, like schools and colleges, to seek medical attention, hospitals, and of course, to seek redress and file complaints and find justice, courthouses. And tell me again which ones were left in the bill of those community safe zones that are also recognized by ICE as community safe zones?
Sure, I'd be glad to. So in the House version coming back, it added, this is addition to what the Senate version was, government mental health care facilities, federally qualified health centers, FQHCs, contracted officers by religious organizations or schools. So that's where the religious exception came into play.
Okay, so courthouses were not included.
Oh, no, ma'am.
I think that Senator Rodriguez probably will speak to one incident already in El Paso that's happened where a woman who was getting a protective order at a courthouse, the minute she even got through, before she even, I think, was able to leave the courthouse, she was picked up by ICE, and that's been a real concern. That's added, quite frankly, a lot of fear among our community. So I'll be speaking a little bit more about a little bit later on. Now,
let me address that real quickly.
Okay.
So the scenario you just described was an individual was picked up by ICE at a courthouse. So that is federal law. ICE can do that. It's not SB 4 language that created that situation to occur.
well,
So
actually, it's unclear whether ICE can do that because ICE does have a regulation.
Let me
but-
in that situation, though, a federal agent acting on behalf of what they believe federal jurisdiction
Correct.
to do that.
No, I
did
understand that.
So this is not an SB 4 discussion on that
Well, but
issue.
that's why we wanted something like that in SB 4 to discourage any of police officers from
And we
doing
do.
that.
It has that in
But
there.
so let's move on. And then you said something about bonds. It would prevent a bonds maker making a bond, allowing a bond.
Let me tell you what the scenario that painted. This was by Chairman Guerin, actually, and I think it was experience and it was brilliant. I wish I had thought of it. But evidently what was going on is an illegal undocumented was being arrested effectively and bonded. The bonding company would literally come in and bond them, and then they would be picked up and taken in by federal authorities, and then the bonding companies were coming in and saying, you got to pay us now, he's been taken off by the Fed. So the House version stops that in unfair treatment through the bonding process for illegals or undocumented that are in temporary custody. They're not going to be forfeiting their bond now.
So they would not be allowed to post cash bonds, is what you're saying, or surety bonds?
They're not going to be
penalized.
penalized. They're not going to lose their bond by virtue of the fact that they're in temporary custody of the Feds.
So this is something we're doing to what? Protect the bonds maker?
Protect the arrestee, the illegal in this situation.
Well, I think my concern would be any time where it's
It
appropriate
didn't
that
change the
someone...
bonding's opportunity. It just, they will not forfeit their bond if they're taken into
Well,
temporary
I'll look at
custody.
the language because, again, I haven't been able to
sure.
see it, but my concern would be that if anybody was entitled to post any kind of bond, whether it was personal recognizance, a surety bond, or a cash bond, that nothing in this bill would prevent them from doing that, posting the bond.
Right.
I'm not talking at the bonds maker and what they need
It
to
doesn't
do.
change the bonding opportunities for the undocumented. It just says you don't forfeit your bond if you're taken into federal custody.
All right, and there's been a lot of reports that have concerned many of us and brought even more fear among our community, that there was a lot of discussion and amendments that were turned down in the House related to whether or not children could be stopped as they're lawfully walking down a sidewalk or playing around their schoolhouse or any of the areas that some people consider, saved zones for children, whether it's, and I think yesterday in one committee hearing we talked about even the playgrounds at McDonald's are perceived as a children's zone. So tell me what's done or not done regarding children in the House version.
So specifically, currently in today's law, the inquiry, if you will, is available upon lawful detainment. So that would infer that those children are committing a crime, so that doesn't fit that scenario. But you cannot, for the sole purpose, inquire regarding your immigration status if that's the only reason you're being contacted, if there's initiation of contact. So Senate Bill 4 didn't change current law today. It's not current law that I can walk up
when you and I discussed this yesterday, I told you that I respectfully disagreed with that, and you said that there was already a federal law that allowed immigration to do this, and I still haven't seen that law, so I'm still... You're suggesting that right now, police can stop a child and make inquiries for any reason?
No, not at all. That's not what I said. No, put words out there.
So that's what I'm trying to clarify.
So to make it clear, under no circumstances that I'm aware of, as a non-federal immigration officer, do I have the right to inquire about your documentation or lack thereof, unless you're in a lawful detainment situation. So if my sole purpose is to inquire of your immigration status, that is not available in today's law, nor would it be available subject to SB 4, unless you're in a lawful detainment situation. So the idea of a children on a playground being pulled aside by an officer to ask them of an immigration status, that's not law today, nor would it be after SB 4.
Right. So did the House define lawful detainment?
All detainers are assumed to be valid in the eyes of the Attorney General in Texas.
No, well, I'm not talking about the detainers. I'm talking about a lawful detainment as someone is walking down the road or walking down the street.
If they haven't committed a crime, no, it would be a lawful detainment.
I'm sorry?
If they haven't committed an offense to justify them being stopped, then no, they wouldn't qualify for that inquiry through lawful detainment. You've got to have a purpose other than immigration status inquiry to stop someone.
All right. So, in your mind, the detainers that we were discussing and debated here, and I'm sure were debated over there, I think you used the words, they're lawful or they're legal on their face?
The Attorney General for Texas, my understanding, will consider all detainer requests valid until noted otherwise through the federal court system that says they're not. And that be the law, Congress or feds tell us what a lawful detainer looks like. Until then, all are presumed to be valid.
Well, I was not aware the Attorney General had said that, because obviously most courts have said that, and most people agree that they're not.
Some.
But, well, most people that I'm aware of and that are legal experts that have looked at the detainers do not consider them as lawful orders. They're simply requests.
I hear you.